Good afternoon, Your Honor.
And Mr. Hanukkah, just so you know, we are running a little bit behind today. We had a plea docket that went a little over, so we haven't even done first appearance.
Judge, I'm sorry, I can't hear you. I don't know if you can hear me.
I can hear you. We haven't done I was telling him we haven't done first appearances yet because we went over with the 1:30 plea docket. So we're just getting started on first appearances. And I understand that you have a plea on the 2:15. Is that right, Mr. Hanukkah?
That's correct, Your Honor.
Okay. So if you don't mind waiting a little bit,
Nope,
we'll call you as soon as we're done. Okay.
that's fine. Thank you.
All right. Sounds good. All right. Ms. Karimi, it looks like the first person on my list to call would be Benson Badair. Good afternoon, Mr. Badair. The court has reviewed your booking information, does find that there is probable cause. The court is ordering that there will be a no trespass at the Mustang Center at 12250 Tamiami Trail East, Naples, Florida. In addition, I should advise you that you do qualify for pretrial release, so should you wish not to post the bond, you could also have the option of signing up for pretrial release. On the charge of resisting arrest without violence, the court is ordering a $2,000 bond, and on the loitering and prowling, it would be a $1,000 bond. As I said before, you have the option of signing up for pretrial release if you'd like to instead of posting the bond, okay? All right, thank you. All right, so next would be Keith Bannon. Mr. Bannon. Sir, you are here as a fugitive from justice out of Broward County. My indication from Broward County is that you are to be held no bond. That will be the continuing order of this court, sir. Yes, you may. Well, this is the information I got is it's a violation of an aggravated stalking injunction out of Broward County. So if you want to address it, you're going to have to address it in Broward County. If they do something down there that terminates your case down there, obviously we would have to do the same. Okay. Okay. You're going to have to take it up with the judge in Broward, sir. I don't have jurisdiction to reconsider a Broward judge's order. I'd be happy to look at it if I could, but I can't. Okay. Well, you definitely need to take it up with the judge there, sir. Okay. Demirical Flournoy? Mr. Flournoy? Good afternoon, Mr. Flournoy. The court has reviewed your booking information. It does find that there is probable cause. On the possession of more than 20 grams of cannabis, it will be a $5,000 bond. On the paraphernalia charge, it will be a $2,000 bond. And your fugitive from justice charges out of Polk County were set by the Polk County judge at $250 on the failure to appear on the DWLSR and $1,000 per charge on the other two, one being possession of marijuana, not more than 20 grams, and a paraphernalia charge. Okay? Thank you. Here we go. All right, next would be Marvin Martinez Bustillo.
Marvin Martinez Bustillo.
Mr. Bustillo, do you require the services of the Spanish-speaking interpreter?
Señor Martínez Bustillo, ¿necesita usted los servicios del intérprete de español?
Yes.
Sí, tiene que hablar.
Do you understand English or do you only understand Spanish?
¿Usted entiende inglés o solo entiende español?
Court will make a finding that this gentleman requires the services of the Spanish-speaking interpreter.
Que el señor necesita los servicios del intérprete de español.
The court has reviewed the booking information, does find probable cause.
El tribunal ha revisado el informe y ha encontrado que hay razones fundadas.
Bond will be set at $2,000 per count.
$2,000 por cargo.
In addition, the court is signing an order that you possess no firearms.
También, adicionalmente, el tribunal está firmando una orden, usted no puede tener armas de fuego.
You must relinquish any and all firearms within 24 hours of your release from jail.
24 horas después que sea puesto en libertad, tiene que entregar todas las armas.
I also note that there is currently an immigration hold.
También he notado que hay una orden de inmigración en su contra.
In the event you are sentenced on these crimes,
Y en caso de que usted sea encontrado culpable de estos delitos,
your sentence could be reduced in order to facilitate your transport to a detention facility.
su sentencia puede ser reducida con vista a que pueda ser trasladado por centro de inmigración.
Thank you.
Gracias.
What's that? Oh, okay. Thank you. We should probably make sure we don't have anyone this afternoon either. Doesn't,
Oh, the minimum.
I have a 2:15 too. Let me just look. I'm not sure about the 2:15.
I'm next door anyway. I'm not going anywhere.
Oh, okay, wonderful. Thank you. Stephen Riley? Good afternoon, Mr. Riley. Court has reviewed your booking information, does find that there is probable cause. On the DUI refusal, the court will impose a $2,000 bond. On the habitual traffic offender, driving while license suspended, canceled or revoked, it's a $5,000 bond.
Your Honor, the state would be requesting the court to also issue a sober link as a condition of bond. In 2011, he pled to a felony DUI fourth offense in Collier County. He has multiple prior DUIs and he's back again for a DUI related offense. So we're asking the court to add a sober link.
I am not going to impose the sober link. If the DUIs were real close in time, I probably would, but I'm not going to. Thank you. All right. Mr. Marquis William. Mr. William, good afternoon. Okay, the court has reviewed your booking information. Does find that there is probable cause. Yes, ma'am.
Because he is currently on an ROR status from Lee County, that FTA warrant that was served on him for Lee County, we're asking the court to revoke that ROR in the Lee County case 20 CT 1693 because he did pick up new criminal charges here in Collier County.
Okay, that would be granted.
And I provided an order to your J earlier today.
Have it.
Thank you.
Okay. All right. Sir, you have 2 counts of being a fugitive from justice, 1 out of Marion County and 1 out of Lee County. Both of those have indicated to the court that you should be held no bond on those. So that will be the order of the court. For some reason on the first appearance order, they don't have the fugitive from justice for Lee County on here.
My guess is because it was an ROR on the warrant.
Okay, and I just signed the order revoking it, so we're good. All right, on the fleeing and looting, it'll be a $5,000 bond. On possessing a firearm by a convicted felon, it'll be a $10,000 bond. And I've already addressed the fugitive from justice. The failure to register will be a $1,000 bond. Leaving the scene of an accident will be a $1,000 bond, and driving with suspended license will also be a $1,000 bond. Thank you. Thank you. Yes? It was actually, I misspoke. It was carrying a concealed weapon.
Actually, Your Honor, it's ammunition.
It was possession of ammunition.
Oh, this was the ammunition case. That's right. I'm sorry. It was ammunition. Also, sir, I'm signing a no firearms order, which requires you to relinquish any and all firearms within 24 hours of your release. That's right. Thank you. Okay. And that is everybody in 31B, right? Good? Thank you.
Thank you. Hello, can you hear us?
Yes, please.
And everyone over here has been sworn as well?
Yes, Your Honor.
Okay, wonderful. All right, so the first person that I'm going to call is Rocio Cintora. Is it Rocio Cintora? R-O-C-I-O and last name C-I-N-T-O-R-A? Good afternoon, Ms. Cintora. The court has reviewed your booking information, does find probable cause. Your bond will be set at $2,000. However, you also qualify for pretrial release. So you have that option. Should you not desire to post the bond, you could sign up for pretrial release. Court is finding this is a domestic violence case and that there will be no contact with Eric Joshmani Garcia Aguirre. Hope I'm saying that right. And the court will allow you to go to the residence one time with the assistance of law enforcement in order to retrieve your personal belongings, hygiene items and things like that. If you want to do that, you just need to do so within 72 hours of your release and coordinated through law enforcement. In addition, the court is ordering that you surrender any and all firearms within 24 hours of your release. Also that there will be a no trespass for 4410 2nd Avenue Northeast in Naples, Florida. Thank you. Sure.
If I post my bail, how long is it until I can go back to?
I have no idea. This order is entered until further order of the court. It will depend on the judge that you have and whether that judge will allow you to go back to the house during the pendency of your case or whether, what will happen with that. I don't have any idea. Okay, you're welcome. Okay, yes? Next is Alicia Nicole Pagan.
Yes, Judge. Good afternoon, Judge.
Good afternoon.
Again, Bruce Roystacker, representing her before you.
Okay,
Judge, the complaining witness, who is also a boyfriend for quite a while, is here, and he is going to be speaking to the victim advocate in the state attorney's office with the hope of having this matter dropped. She has no prior criminal activity, and I think the write-up here on the police document doesn't actually portray what actually happened. Do you want to proceed first, or can I continue? Or?
you can continue. I'm guessing that you want to address the issue of whether the court orders a no contact, no trespass. Is that what we're having with this?
And that's where I'm at. And I'm hopeful because she has nowhere to go, no friends here, no family. They just bought a condominium actually yesterday.
Okay.
And this whole incident was apparently a result of probably some over celebrating, and one thing led to another. So he is here, and he certainly wants her to come back to their new condo.
Okay. Ms. Karimi, can you hear Mr. Roystacker?
I can, Your Honor.
Okay.
Thank you.
All right. I'm going to need to take some sworn testimony, please. Are you going to have this gentleman testify?
Yes.
And only on the issue of the no contact. I don't want to hear about the facts of this
Oh,
case.
absolutely.
Okay, thank you. Sir, you need to raise your right hand and be sworn.
You swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth.
Sir, please state your name. And what is your relationship with Mr. Young? And you bought a condominium, did you? Yesterday. And as a result of this incident, what transpired, are you afraid of her? Are you welcoming her, want to welcome her back? And is it a fact that she has nowhere to go, has no friends here? And the only place she has to go is to your apartment, your condominium that you bought yesterday. Judge, I think that that is sufficient. He has no fear, right, of her. You don't need anything legally to protect you in order to protect you from her. And are you testifying voluntarily and truthfully?
Ms. Karimi, you have questions?
No, Your Honor.
All right, so first off, the court has reviewed the booking information, does find that there is probable cause on both counts. The battery will be a $2,000 bond, and the resisting arrest without violence will also be a $2,000 bond. Based on the testimony from the alleged victim, Mr. Gall, the court is not imposing the no contact, no trespass. However, the court is ordering a surrender of any and all firearms within 24 hours of your release. In addition, the court is ordering that there will be no alcohol during the term of your release pre-trial.
But is there a resisting as well? I thought
Yes, sir.
it was just a simple battery and
There's the resisting without violence and a battery.
okay.
If in fact it is true that this was fueled by alcohol, it may be possible that this lady has a problem, because my reading of this booking sheet is that other than when she's drinking, they seem to be fine, but as soon as she drinks, she becomes violent. So if drinking is the problem, which it sounds like maybe it is part of the problem, then the court is going to order no alcohol, because it is definitely against my better discretion to send her home. But I am hopeful that simply without alcohol in the mix, that maybe there won't be this kind of behavior. So that will be my order. Understand, ma'am, that if you violate the alcohol provisions during the term of your release, you will be right back in jail. Okay, thank you.
Thank you, Your Honor.
Thank you, sir. Okay, the next person we have is Joseph Owens. Mr. Owens? All right, this is also a domestic violence related case, and I see that we have, are you here to testify in this case, ma'am? We need to get you sworn in.
Swear affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth.
What is your name? What is it? I'm sorry, you're quiet. Aisha Carballo? Okay. And what are you here today to request? So is what you're asking is for the court to release him so he can go to David Lawrence Center, and you're also asking that the no contact order not be entered? I don't have a trespass, I only have a battery.
I'm sorry, Your Honor, I can't hear either party.
Okay, Ms. Aisha Carballo just stated to the court that there was no battery and she wants this defendant released on his own recognizance so that he can get into treatment. So the issue with him is treatment. And also the defendant, Mr. Owens, indicated, and she also indicated she doesn't want the court to impose a no contact. And then also Mr. Owens chimed in and said he doesn't want the court to impose the no trespass. Okay. Is there anything else you want to tell the court, Ms. Carballo? Okay. I want you to understand that before I came into court today, not only did I read the booking sheet, but I read your DCF file. I read the shelter petition. I am not going to lift a no contact in this. There will be a no contact order entered for your protection and for the protection of your baby who's not even a year old. I understand that you want him home, and he's going to have to get the help himself. Because it looks to me, at least from what I've been reading in an extensive court file, that there have been many efforts to try to help save him from himself. And what I read, and I'm not passing any judgment on you as to whether it is true, but what I read in the court file, not just the file that I have in front of me, but in your DCF file, is that he is a danger to you and your almost 1-year-old son. So I am not sending him home. No way. If he gets out of jail and he leaves jail and he wants to go to David Lawrence Center or he wants to go to the hospital, and sir, you want to get the help that you need in order to become a better person, that would be awesome. But I cannot let him near you right now, or that baby. No. I will tell you this. I will make the following provision. If the Department of Children and Families makes a provision for the two of you to have contact and communication for the purpose of parenting your son through the DCF proceeding, the court will allow it. But my order right now keeps you away from each other. So I am ordering that there will be no contact with you, Ms. Carbello. And also, sir, that if you want to get your personal belongings, you can do that with the assistance of law enforcement within 72 hours of your release. But I am ordering the no trespass at 2777 Shoreview Drive, apartment 10, Naples, Florida. The additional condition, as I said before, ma'am, will be that contact and communication and let me see. I want to pull that case up. Will be as directed through, if any, through the dependency proceeding. So it'll be up to Judge McPhee to determine whether there should be contact and communication between you. I do see that you both have lawyers and you both have a case plan that's coming up. But I can tell you right now, this proceeding may affect that. So my position right now is probably for the benefit of both of you, and particularly for the benefit of your very small child, keeping you two away from each other is what makes me sleep at night. So I can't do it. No way. Not with the history. Maybe you can bring it up again with whoever the judge is that handles this battery case somewhere down the road once you guys have worked your tasks in the case plan and that there's some showing of progress on the drug issue, on the parenting issues, and on the violence issues, whatever else other issues you guys have in the dependency court. But when we're in criminal court, I have to take all of that into consideration. And when I saw your history, it gave me great pause. And I feel like you're in danger, despite the fact that you don't. It's my job. It's my job to protect you and also to protect your baby. And so that's why I'm making this order today.
Judge, did you set monetary bonds?
Oh, I did. I thought I did. Did I not? No, I didn't. How'd I miss that? I'm sorry. Court finds there's probable cause, bond is set at $7,500.
Or there's two counts, Judge. There's a battery and a possession of heroin.
I didn't get a possession of heroin. I only got the battery.
Oh, I'm sorry,
I thought this was an additional charge.
Yes, you're right. I apologize.
That's okay. Right, that one's already been addressed, right? Yes, sir. Yes?
Would you consider, when I say this, I'm not saying this as in, so I can go back to see her or whatever. My main goal is to obviously get treatment. I have my own funds. 7,500 is a little too high for me to get to my treatment program, to get to David Lawrence from the jail. Like they transport me from here if I can bond out. Could you set my bond a little bit lower than that, please?
Well, I'll tell you this. I mean, that's not up to me because I have set your bond. But if David Lawrence Center lets the court know that they have a bed for you and that they're willing to facilitate a transfer, that could be a provision of your pretrial. But until I have something solid from David Lawrence, I'm not considering that. I want you right where you are right now until we find a place for you to go. Mm-hmm.
So when I go in that from here, I have to go from here to David Lawrence.
Understand?
So could you give me a little less lower bond so I can get there?
I am not lowering your bond. I will tell you, they have a very good program in the jail that helps people who are seeking recovery. It's called Project Recovery. You can always make application to get into that program. I am not lowering your bond. I actually think I set it too low based on the history. So no, bond set at $7,500. All right, next we have Michael Simonetti. Oh, he's a refusal, okay. Yes. Oh, how did I miss one? I always miss one. I know. Well, I sign my name in advance so that I make sure that I get them done, and every once in a while I miss one. Thank you for catching that. All right, Mr. Simonetti, I have reviewed his information. Also do find that there is probable cause. Bond in Mr. Simonetti's case will be set at $5,000 on the fentanyl, $5,000 on the cocaine, $2,000 on the paraphernalia, and $500 on the tag not assigned. Thank you. All right, that concludes our 2 o'clock docket. Let me see who I have in the waiting room. I have some other matters that are set for today as well. Good afternoon, everybody. I just want to let you guys know we're real behind in court. We're getting ready to start the 2:15 docket. So just bear with us, and we'll get to everybody. Okay.
Okay, I was running late too, so.
Okay. Yeah, I think I was optimistic about how we get through this docket today. Overly optimistic, I guess. Are you leaving, sir? You're done? Well, Happy New Year to you. Thank you. All right, so we've got on the 2:15, we have a plea for you, Mr. Hanukkah. Do we want to take that first? 2018 CT 337, or 1337, I'm sorry, Daniel Lynn.
Yes, Your Honor. Daniel Hanukkah for Mr. Lynn.
Okay, and is Mr. Lynn, is it a plea in absentia, or what are we doing with this one?
He's in custody, Your Honor.
Oh, he is, okay, so we need Mr. Lynn. Oh, okay. Let's address Miss Elizabeth. Is this Elizabeth Rivas? And we've got 2 cases, 20 MM 1814 and 20 CT 2144. And Mr. McGann, we've got you, right?
Yes, ma'am. I'm going to be handling this one.
Okay, wonderful. All right. Yes? Oh, he's an IJC, Mr. Lynn is? Okay. All right. Well, let's take Miss Rivas. All right. So we've got 20 MM 1814. Let me look at this. Looks like her bond was revoked on 12/9. Let me see. And then also in case number 20 CT 2144, bond was revoked the same day. And all right, Mr. McGann, this is your motion to set bond in both cases?
Yes, Your Honor. You actually were the first appearance judge on the new charge that she had picked up.
Yes.
And did revoke her bonds that she previously posted on 2 DUI charges and 2 battery charges. And as a result of that, she's been in custody since about December 2nd, being held on no bond. So Attorney Wilson, she did file a motion to set a bond on the charges that the bond was revoked.
Okay.
And in lieu of taking testimony from Ms. Rivas, she has lived in Collier County for 2 years, in Florida her whole life, primarily in Hollywood, Florida. And she was employed at the Chili's prior to her arrest, and a majority of her family does live in Hollywood. So she's coming before the court in order to have a bond set and to possibly be released with the condition of sober link device. And we would ask the court for a reasonable bond.
All right, Ms. Karimi?
Your Honor, the state objects. In November of 2020, she was arrested for 2 counts of battery with a DUI, DUI damage. There was a crash in that case. Her breath alcohol result was 0.124. Less than a month later, she's arrested again for another driving under the influence here in Collier County. That breath alcohol result was 0.213 and 0.207. Your Honor was the first appearance judge for that second DUI case, where you did grant our motion to revoke bond in her battery and her prior DUI case. While I understand she does have ties to the community, to Hollywood at least, this was a violation of her bond. The charges were similar in nature. They're high breath results. There was a crash in her first one. And so at this point, it's for the protection of the community that she remain in custody. And so we'd ask the court to deny the motion in 20 MM 1814 and 20 CT 2144.
Response, Mr. McGann?
Primarily alcohol related, so I believe the community can be protected with the sober link device. That would require her to blow into a machine multiple times a day. I don't think she has any problem with doing that, so we just ask that a reasonable bond be set so she can go back to her job.
Mr. McGann, I'm not comfortable setting a bond in these 2 cases based on everything that I've read. I just can't. I just don't think that the only issues involved here are the alcohol and the sober link. So the court is going to deny the motion for bond, but would say, just like I said to the individual before you, that there are opportunities to work on your sobriety while in the Collier County Jail, and working on your sobriety and showing the court that is your intent when you're in jail can go a long way with this court when deciding how, and if it comes to that, how your case should be looked at. So, Mr. McGann, I understand your position, but I've looked over everything on this, and I do remember the first DUI, and I am just not comfortable setting a bond right now. And I do agree with Ms. Karimi. It is for the protection of the public, and I also believe that it's for her own protection at this point too. So,
yes, Your Honor. How would you like that order? Should I email one over to your JA or
yes,
possibly fill one out in the courtroom? I'm just not there.
Yes.
Email. All right. Thank you very much.
Thank you, sir. All right. And let's see here. That will bring us to our 2:30. Oh, I still.
Over to
Oh,
IJC.
yes, we have to move over to IJC. You're right. Thank you.
Okay, thank you guys. We're switching over to IJC for right now. Temporary.
Thank you.
Thank you. Nice seeing you guys. Happy New Year.
Thank you, gentlemen.
Thank you. That's right. We're not done. Sorry, Mr. Hanukkah. I just blew right by you.
That's okay.
Hello.
Hi over there. How we doing? Now, this gentleman hasn't been sworn, is that?
I think I lost you. I think we got disconnected. Hello?
I'm here.
I think we lost the judge.
It must have crashed.
Arna Makali. Oh, there she is.
We haven't done anything. I just, I believe that what has happened is, I think we had a problem with the internet connection, so I just refreshed it and it looks like we're ready. Okay, we are ready with Mr. Lin. We just got him sworn in. Mr. Hanukkah, I don't know if you were able to hear us, but.
No, but that's fine, I believe.
Got him sworn in, and I just need to get myself caught back up. Let me just get over here into his file. And this is case number 18, CT1337. And for everybody who's just joined the Zoom meeting, we're on our 2:15 plea docket. I have a 2:30 eviction, and then we'll get to the 3 o'clock. We're just a little bit behind today. All right, and Mr. Lin, it looks like he's charged with a DUI third more than 10 and a refusal. Is that right?
This
No, Your
is a
Honor.
violation of probation. He violated his refusal to submit to testing probation.
Sorry.
Correct.
I was just looking at the charges on the bench, and let me find the VOP affidavit then.
Yes, Your Honor. He has 4 condition violations. There's an amended affidavit that was filed June 3rd of 2020. My understanding is he's completed all the other conditions. The only thing that's remaining was the new law violation. He's going to admit to the allegations contained in the affidavit. The agreed upon resolution was to revoke and terminate, sentence him to 150 days in the Collier County Jail with credit for time served. We believe that credit to be 122 days. 7 of those days, Your Honor, were from when he was arrested on the VOP warrants in Brevard County, and the state, Mr. Rushkin, I think.
Rusinko.
Sorry about that. Has agreed to the 7 days credit from those counties as well.
Okay. All right. So, Mr. Lin, were you able to hear all of that? Okay, good. Because I mean, sometimes I've got a computer over here, and I've got you way over there, and I got a microphone in the middle. Do you agree with the disposition today of your violation of probation? Is that what you'd like to do to get it resolved? So are we going to agree on the record to give him 122 days credit? Is that what we're doing, Mr. Hanukkah?
Judge, I'm counting if I could just have a minute.
Okay.
Yeah, I had 7 days from out of county and 50,
100.
Go ahead.
122 total is what you said, Mr. Hanukkah?
Yes.
Okay. Yes, Judge, we're in agreement with putting 122 in the judgment.
All right, fantastic.
And that should result in his release on Friday.
Oh, okay. He said that that'll result in you getting out on Friday. It's conditions 2, 5, and 2 counts of 12. 2, 5, 12, 12. All right, sir. Could you please state your full name and date of birth for the record? And sir, do you agree that on December 26th of 2018, that you were placed on probation for the offense of refusing to submit to DUI testing after a previous suspension for a prior refusal?
Yes.
And do you agree that you subsequently violated that probation by violating conditions 2, 5, 12, and 12? Have you reviewed and signed a violation of a probation admission form?
Oh, shoot. Lost him again. I think we're having issues again.
Oh my goodness. All
I
right.
see, I'm there. I see,
There we
Judge.
go. I got Monica.
I think we
Did
lost it.
everybody else- You're
Yeah.
I'm here, Judge. I'm gonna keep my camera off, Judge.
What's that?
He's
I'm
leaving her
gonna keep-
video off, I think.
Oh, okay. It's saying the internet connection is unstable and
Dan, we could call her JA. She could transfer us into the courtroom.
Okay, I don't have that number. Oh, I think
It's 252-4262.
262, okay.
Yeah, let me call her.
Oh, she's back.
We're here, Judge. Can you hear us?
I can.
All
Okay.
right. Just
All right.
just one more.
We're having some,
We're so close to being through this. Okay. Did you guys hear the plea colloquy or most of it, I hope?
I did not, Judge, but you know, if it's on the record, then that's sufficient for me.
It's on the record.
Okay.
All right, sir, the court is going to accept your admission, is going to revoke and terminate your probation and sentence you to 150 days in the Collier County Jail with credit for 122 days in jail. And what was the other condition? Was that it?
that should be it.
It's revoke probation.
I said revoke, right?
Yes.
Revoke and terminate.
Correct, revoke and terminate.
Is there a cost of prosecution that's being imposed, Ms. Karimi?
Yes, Your Honor, the state would request cost of prosecution.
And also the cost of prosecution, sir. And I think that's everything.
Thank you very much, Your Honor. Thank you very much. Thank you, Ms. Karimi. Everybody have a
Thank
happy
you,
New
Mr.
Year.
Hanukkah.
What are the costs? Oh, it's just $50. You're gonna pay that within 30 days, okay, sir? All right, good luck to you. Thank you, sir. Oh, yes. A long, long day.
Are we staying on this Zoom for the juvenile, I guess, because everybody seems to be here?
Yep, I thought I was signing on to Judge McPhee's, but it looks like perhaps his assistant just had everyone sign on for this one, which actually works fine. I do have a 2:30 first, however, that's gonna take only a couple of minutes, I think. So we need to, that looks good. Thank you. Just check with the jail as to whether they have, let's see here. I know I moved them. Let me go back to my docket. And it would be, it's Mr. John Carrera and 20 CC 1722. I know that my office called to make sure that he could be present for this hearing. He should be at the Naples jail. Oh, okay, and I do see her. She's all ready. I don't have a witness. I just have Mr. Sawicki. Oh, the mom is here for Mr. Carrera? She's here for the juvenile, I believe.
Yes,
Yes. We're going to start with Mr. Carrera. Are you Mr. Carrera? All right, Mr. Carrera, this is Judge Nicola. Your eviction proceeding was scheduled for this morning. And I have attorney Richard Sawicki, who's over the Zoom app. And I reviewed all of the pleadings in your case, which suggests to me that your eviction proceeding is proper. Do you have any defenses to the eviction, sir? I need to get you sworn in. Please raise your right hand and be sworn.
Do you swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
landlord told me that he wanted to evict me due to my background. And that was his negligence as a realtor to not do a background check and have me ran and everything and have given him money. I've been paying the rent every month, even this month. I think it might have that he had a check of mine for 2 months of January as well that he could cash in, and just in January comes in. Well, so I mean, like I explained to him, if he would have told me from the beginning when I signed the lease agreement and everything that I should, he did the background check and didn't want me to live there, that would have been a different story. I would have saved all my money and somewhere else, but he didn't do that. He had me live there and kept me there and then decided to evict me that months later.
Okay, let me get a response from Mr. Sawicki. Mr. Sawicki, Mr. Carrera says that the reason why the eviction is filed is not due to non-payment of rent or any behavior on his behalf, but due to the fact that the property owner didn't do a formal background check before this gentleman moved into the property. And once she got his background check done after he had already moved in, she decided she no longer wanted him there. Is that true?
Yes, we are not going to renew his month-to-month lease.
So he's been on a month, hold on. He's been on a month-to-month lease, and Ms. Lutke, as I understand it, does not want to renew it. So let me take a look. Would you agree, Mr. Sawicki, that this gentleman has been paying his rent every month like he said he has? Is he not behind on the rent?
That is correct. We received November, because I had given him notice in October of intent not to renew. And then he did pay for November rent. That check has not been cashed, and we have not received December's rent. And if we did, we will not be cashing that check either. But now, since he's been here that long, we would ask the court to be able to cash those checks, and then we are in receipt of last month's rent deposit, which we would, if he has submitted December's rent, then we will return that to him. If he has not made December's rent, we'll be using his last month's deposit for December rent.
Okay. And Mr. Sawicki, would you agree? I'm looking at the complaint that was filed by Ms. Lutke, that, let me just make sure. Okay, she filed the complaint for eviction. And that the notice that was given by Ms. Lutke was the notice of termination of the lease, the 7-day notice to vacate?
Yes.
Sir, that notice is insufficient under the law to terminate a month-by-month tenancy. And I can't tell you why, but I can tell you that the eviction is denied without prejudice. The notice is improper. I can't throw him out. So that's the dilemma.
Even though I gave him a notice not to renew.
It's not a proper notice. I can't tell you what the law is, but I can tell you that this notice is not sufficient pursuant to Chapter 83.
Okay.
And I cannot evict somebody without them having been provided the proper notice.
Okay.
Okay, so the eviction is denied without prejudice. Mr. Carrera, even though I've denied the eviction today, it doesn't mean that this may not come back up again in the future. If you do get out of jail, it's your responsibility to keep the court advised of any changes. I didn't know that you were in jail until Mr. Sawicki told me this morning. So, we need to know where you are. All right, that concludes the eviction proceeding for today.
Very good, thank you.
All right, thank you. Yes, sir. Oh, you're welcome. Thank you. Okay. All right, so we now are back on the record, and I've got to go into my morning again. Let's see here. that?
Would it be any vertigo Bravo or?
I don't know. Oh, well, no, he's a juvenile, so he would be in detention. And actually, I think he's over Zoom. I think I
Yes,
saw.
you're correct, she's over Zoom. Okay,
Yes,
good.
so we're good. We have Collier detention. We have Miss Karimi.
I'm just gonna keep the camera off to help with the internet.
Okay, thank you. Do you think that's what interferes with it, is having so many people over?
I have no idea, but that's what I'm gonna tell myself.
Yeah, I mean, I had like 30 lawyers over traffic Zoom this morning, and I didn't have all those problems. But then this afternoon, it's just kind of going a little haywire. But okay, and ma'am, you are Mr. Jean's mom. And what's your name? How do you spell your last name? Leanla. Sorry, I can't, just having a hard time. Laneaud. I think I got it. Okay. Yes, ma'am. Yes, she was. Yes, Marilyn is there. So we're good. Thank you for today. You have a Happy New Year yourself. Okay, do we have everybody over Zoom that needs to be over Zoom to address Mr. Jean's matter?
I think so, Judge. It looks like DJJ is here. The public defender is here.
Okay, wonderful. And we've got his mom present in the courtroom. All right. So what happened this morning? Why was Mr. Jean here? Because I certainly didn't want to do a pickup order on him, and if I would have known that he got here a little late, I probably wouldn't have had him taken over to detention. But I had no idea.
Your Honor, I overslept, and then on my way there was a little bit of traffic. I don't know if it was a crash, but they were making us pull off to the side, and that took like 10 minutes. But I was about 30 to 20 minutes late.
Yeah, and I was done at 9 o'clock, and your hearing was actually I was done at 9:10. I finished at 9:10, and so when I finished, and I had to go to another courtroom where I had more than 100 cases. Yeah. I understand. Well, no, it's not your fault. It's his fault. He's was a juvenile. He's now 18 years old. And when you know you have court, you got to get up earlier, because this is what happens. I mean, if I didn't have the time this afternoon, what if I would have left early? He would have sat in juvenile detention all night long until he could have been brought back before the court tomorrow morning, because he was late. So you can't be late. I start on time. I expect everyone else to be on time. Maybe you need to get 1, 2, 3, 4 alarms, have somebody call you. I don't know, but you know, this is an unfortunate consequence of what happens when you're late for court. And if he were an adult, you know, he could be in for longer. He could be on bond and his bond could be revoked. I mean, and now he is 18, so we just got to make sure you stay on track. Okay, Mr. Jean?
Yes, ma'am.
All right. So we are here today for you on a violation of your probation. Have there been any discussions with respect to Mr. Jean as to how we could resolve this, or what do we want to do for him?
Your Honor, I did convey an offer of indirect contempt, 15 days in secure detention. He would maintain his withholds, and he has a pending formal violation with an arraignment set on the 11th. If he accepts the 15 days today, we'll dismiss that formal violation and cancel the arraignment on the 11th.
Okay.
Your Honor, I spoke with him earlier today when he had arrived, and he had indicated to me that he did wish to accept the 15 days. And he wanted to be sure that he would maintain his withholds, and as the state has stated, he will.
Okay. Ms. Lynott, are you in agreement with your son's disposition today? Are you in agreement that we could resolve his violation by way of an indirect criminal contempt order, which would require him to serve 15 days in detention? But if he did serve those 15 days, he would still maintain his withheld of adjudication of guilt, which means they're not requiring him to be adjudicated guilty of the underlying offense, which is good for him. But that's, you know, I need to know that you and your son are in agreement as to resolving this, this allegation, which appears to be associated with marijuana. That's okay. What do you want to say to me? That's why we're here. We're here about your son today.
After when you give me the stay home, he's not going nowhere, he's still home.
Yeah, he's still home, but he's still having some trouble. When you have kids and they're in trouble, and they have requirements of things that they have to follow, they've got a lot more rules than they would have if they were just at home and not in trouble. And he's in trouble. And one of the rules was that he's just not allowed to, he's not allowed to smoke any marijuana. And I don't know if it's going to be a lot worse for him after today if he doesn't accept this offer, but I know that they're filing a formal violation against him, which could result in different penalties. And the state attorney's office is saying today that if your son accepts this 15-day penalty, that they will not go forward on the formal violation, and also that he would maintain his withhold. If that's not something you want to do today, I could move this to Thursday, like I did with a gentleman this morning, give you an opportunity to think about it, also to speak with your son. But that's what I would probably do, Mr. Robio, just like I did with the child this morning. I would probably move him. I think this was Mr. Roblero this morning. I would bring Mr. Jean back on Thursday.
Your Honor, the difference is that Mr. Jean is 18 and he can make this decision on his own without the consent of his mother.
Oh, that's right. That's right. I forgot he had already turned 18. All right. So, ma'am, respectfully, because your son has reached the age of 18 on November 3rd, it looks like, he is able to make this decision today without the court being required to obtain your consent. And I understand, believe me, I understand that it just breaks your heart. But he's reached the age of majority, so now he has to make decisions on his own behalf. And so, Mr. Jean, I would say to you, would you like to accept the 15 days?
Yes, Your Honor. And is it okay if I explain to my mom in Creole what's going on?
Yes, sir.
Can she hear me?
You can.
Maman, ou pas crier, bro, pas commencer à stresser, ok? J'ai fait bagarre là, la plus facile si je prends 15 jours. Là, 15 jours, ma vie skinny, il faut me tout bas bon. So, ou pas besoin de crier, bro, elle est ok. Ok, maman?
Is that all you want to say, sir?
Yes, ma'am.
All right. Do you have any other questions, sir, before we come to the plea?
No.
Okay. Ms. Karimi, please tender the plea.
Sir, could you please state your full name
Randy Lewis Jean.
and your date of birth?
November 3rd, 2002.
Are you currently under the influence of any drugs, alcohol, or medication?
No, ma'am.
Do you suffer from any mental illnesses?
No, ma'am.
Do you admit that you were placed on probation in this case?
Yes, ma'am.
Were the terms and conditions of your probation explained to you?
Yes, ma'am.
Did you understand them?
Yes, ma'am.
Do you admit that you violated your probation by testing positive for marijuana?
Yes, ma'am.
Do you understand the rights that you are giving up by entering into this admission?
Yes, ma'am.
Do you understand that you will not have a violation of probation hearing in this matter?
Yes, ma'am.
Have you discussed this plea agreement with your attorney?
Yes, ma'am.
And are you satisfied with your attorney's advice?
Yes, ma'am.
Do you have any additional questions for your attorney or for the court?
No, ma'am.
Your Honor, the state tenders the admission.
All right, Mr. Jean, so the court will accept your admission, find that you are in an indirect criminal contempt sentence you to 15 days in secure detention. You will maintain your withholds, and I understand that the formal charges will be dismissed by the state. So, so the time will start today. And I just want to say to you, Mr. Jean, I'm standing here with you, or sitting here, I guess, not standing here with your mom. Your mom is just devastated by this. She's just crying. It's just breaking her heart. And that's what kids do sometimes to their parents. So when you get out, you have an opportunity to show your mom that you can do better, all right? Because you've got rules and restrictions right now. And you have to follow those in order to be a success. And you're an adult now. So you get in any more trouble, you're not under the juvenile rules anymore. You're under the adult rules. And you weren't here all afternoon while I had to go through person after person after person who's violated these adult rules. And they're going to end up in a very bad place. And you've got an opportunity now at 18 years old, just 18 years old, to turn your life around. But it's a one-shot deal. You either do it or you don't. And if you don't, you end up over there with the other people, which is not where you want to be ever. So I just don't ever want to see anybody's mom in court crying. It hurts me right here. So, and it should you too, Mr. Jean. All right, well, good luck to you. And I think that concludes everybody today. I think we're done.
So too, Judge.
All right, thank you.
I sent Miss Judge McPhee's JA. I sent the order to her.
Yes, she'll bring it down to me to sign.
Okay, great. Thank you, Judge. Take care.
Thank you, everyone. You too.